Hello beautiful Kitsap neighbors. It's Betty from Bainbridge Island Uncensored with our best video yet. This is going to be an exciting video. In it we will share the ruling of Kitsap County Superior Court Judge, Kevin D. Hill, who recently knocked down the unlawful protection order from Bainbridge Island Municipal Court Judge, Sarah McCulloch. First, let me tell you why we have made this video. Sadly, many of our neighbors have been told lies about Reneson and are publicly calling him a terrorist, a criminal, a sociopath, and are discussing him as an armed and mentally broken veteran that threatens us all. We are sharing this video primarily to fight this wretched defamation of a military officer who has a distinguished history of defending our nation overseas and fighting for our liberty here at home in court at great personal expense. These lies about Reneson are inexcusable and must be challenged. So please help defeat these lies by sharing this video far and wide and help us support a man who has supported all of us. We also want to provide information on the real reason for the dispute that led to the court proceedings in Moriwaki v. Reneson. These reasons include the wonderful Bainbridge Island Japanese American Exclusion Memorial, located behind me, as well as Governor James Lee, Senator Maria Cantwell, and Senator Patty Murray. You do not want to miss this video. But before we do that, we will let Judge Hull share his ruling that provides the broad strokes of the dispute that formed these taxpayer money-wasting court proceedings. Please note, we have edited and abridged the ruling for readability. For the full ruling from Judge Hull, please visit our Facebook page.
On the record before this court, respondents' actions are protected by the First Amendment. Accordingly, the trial court's decision to grant the stalking protection order is reversed, the stalking protection order is vacated, and the matter is remanded to the trial court for entry of dismissal. Petitioner Clarence Moriwaki and respondent Richard Lee Reneson III both reside on Bainbridge Island, Washington. They have homes near one another. Moriwaki is a founding member and volunteer director of the Bainbridge Island Japanese American Exclusion Memorial Association. The Memorial Association is a non-profit organization that oversees a national historic site relating to the internment of Japanese American residents forcibly removed from Bainbridge Island. The Memorial Association also promotes education about Japanese American internment during World War II. Moriwaki gives speeches and has appeared in various media outlets to discuss internment and its lessons. Moriwaki regularly posts on Facebook regarding internment and related topics. Reneson frequently opines online about the National Defense Authorization Act of 2012, NDAA. He also comments on proposed legislation in Washington state such as Senate Bill 5176, that relates to the detention of United States citizens and lawful resident aliens under the NDAA. He regularly posts about the Memorial Association. Reneson did not Facebook message, text message, email, telephone, or otherwise contact Moriwaki after February the 5th. There is no evidence Reneson has posted on Moriwaki's Facebook page after being blocked. There is no evidence Reneson contacted Moriwaki telephonically or otherwise after Moriwaki texted him to leave him alone. Reneson commented on the personal Facebook page of Moriwaki, voicing his opinions on topics that were relevant to posts initiated by Moriwaki. Moriwaki characterized this as trolling, while Reneson saw it as engagement of political discourse of public concern. Speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest, that is, a subject of general interest and of value and concern to the public. Moriwaki is a limited public figure, specific to the issue of internment and the Memorial Association. Moriwaki is a volunteer board member of the Memorial Association. He has given speeches and appeared in the media discussing internment and the lessons we should learn from incarceration without due process. Moriwaki has commented frequently in public regarding internment and its relevance to the present political climate on both his private Facebook page as well as writing Facebook posts in the name of the Memorial Association. He has also had letters to the editor published in the Seattle Times discussing internment. Whether Moriwaki is a limited public figure, or simply a private individual, Renaissance public internet postings opining about Moriwaki's involvement with the Memorial Association are subject to First Amendment protections. Other case law supports fundamental principles that uphold robust First Amendment protections in the field of public debate. Renaissance internet postings qualify as public debate, and therefore his criticisms of Moriwaki regarding his position with the Memorial Association and challenges to stated political opinions are permissible under the First Amendment. There was never any demonstrated intent to injure, nor any physical threat by Renaissance toward Moriwaki or his property. The closest instance of a true threat is the February 7, 2017, comment where Renaissance used Moriwaki's repeated party metaphor to say he was out on the public street now in front of Moriwaki's house talking to some of his guests. The message was not a true threat. Moriwaki continued to both initiate and engage in private Facebook messaging with Renaissance. Moriwaki ended several conversations with to be continued, as late as February 4, 2017, and liked at least one post by Renaissance between January 28 and February 3, 2017. These acts suggest a desire to continue engagement up until Moriwaki blocked Renaissance from his Facebook page. There is no evidence that Renaissance surveilled, monitored, tracked or otherwise intentionally placed himself in proximity to Moriwaki for the purpose of stalking him, contacting him or interacting with him. There was no obscenity by words or conduct. There is no evidence incitement or speech integral to criminal conduct. After their interactions on February 5, Moriwaki properly exercised the remedy discussed in Cassidy by blocking Renaissance from his personal Facebook page. Moriwaki also had the ability to protect his own sensibilities simply by averting his eyes from Renaissance's subsequent internet postings on other pages after he blocked Renaissance. Following Renaissance's contact of Moriwaki via text message on February 5, Renaissance did not have any telephonic contact with Moriwaki after Moriwaki told him to leave him alone. Renaissance's creation of the Clarence Moriwaki of Bainbridge Island Facebook page is neither defamatory or fraudulent. The Facebook page does not purport to be run by Moriwaki, nor attempt to convince anyone that it is. The trial court did not make any findings that Renaissance posted false statements. Renaissance's internet postings critical of Moriwaki's role with the Memorial Association is permissible and protected speech. Renaissance ceased contact with Moriwaki once there was an unequivocal request to do so. By blocking Renaissance, Moriwaki was able to prevent any further contacts from Renaissance via Facebook. Renaissance has likewise not contacted Moriwaki once Moriwaki texted him to leave him alone. Renaissance did not commit stalking conduct. Accordingly, issue answered the stalking protection order below was an error of law. A stalking protection order is not an available remedy if the speech and conduct complained of is protected under the First Amendment. The communication and conduct in this case falls under the umbrella of constitutionally protected speech. The trial court erred by granting Moriwaki's petition for a stalking protection order. It is hereby ordered that 1. The trial court's decision to grant the stalking protection order herein is reversed. 2. The stalking protection order entered on July 17, 2017 is vacated, and 3. The matter is remanded to the trial court for entry of an order of dismissal.
The First Amendment survives on our island. Now let's talk about the real reason for this dispute. Judge Hull mentioned the National Defense Authorization Act of 2012. He also mentioned the political nature of Renaissance's opinions shared with Moriwaki. More specifically, Renaissance shared his view that Moriwaki, as spokesman for our Bainbridge Island Japanese-American Memorial, which is its motto "Let it not happen again," should not be vocally supporting politicians who made it legal for indefinite detention without charge or trial to happen again, and Rynearson shared his view that Moriwaki should be supporting Washington Senate Bill 5176, but that Moriwaki had remained publicly silent about that bill despite posting about the threat Trump posed to our Muslim neighbors. SB 5176 would make it a felony for Washington officials to cooperate with federal forces that attempt to round up American citizens or legal residents and put them in military prison camps indefinitely without charge or trial. Indefinite military detention without charge or trial sounds familiar, doesn't it? Where have I heard about that happening before, I wonder? When Rynearson posted that James Lee, when he was in Congress, voted for a law giving the president the power to have the military again arrest Americans and legal residents in America without charge or trial and indefinitely detain them, Moriwaki blocked Rynearson. When Rynearson then criticized Moriwaki as unfit to represent the memorial, Moriwaki then had government exclude Rynearson from his own property in violation of his constitutional rights and even lied to a judge in an attempt to have Rynearson arrested, as we showed in a previous video. I am sure some of you think this is a conspiracy theory, that our president has been given the unconstitutional power to repeat the actions of President FDR. I am sad to tell you that it is true. I am also sad to tell you that this power was voted for by Senator Maria Cantwell, Senator Patty Murray, and signed into law by President Obama. Unlike the Pinocchio Squad, I will back up my claims. Here is a quote from the executive director of the American Civil Liberties Union as relayed by the Young Turks.
The next president can, Republican or Democrat. You should have never signed it into law. Now, a lot of people have been making one last charge. Oh, it's Cenk Uygur and Glenn Greenwald and people like him that actually read bills, and I can't believe they read it. How outrageous, when we should just trust the goodwill of President Obama. But it must be just them, right? They're probably seeing it wrong. That's interesting because the American Civil Liberties Union has a whole team of lawyers. They all looked at it, and here's their conclusion. Anthony Romero, executive director of the ACLU, says, President Obama's actions today is a blight on his legacy because he will forever be known as the president who signed indefinite detention without charge or trial into law. So what's the next thing? Did the ACLU get it all wrong?
And here is liberal Chris Hedges, a former New York Times reporter who sued President Obama over this power, joined by Noam Chomsky, Dr. Cornel West, and supported by the children of the great Fred Korematsu.
The Southern District Court of New York, federal court, Judge Catherine Forrest, issued a ruling in September declaring Section 1021 of the National Defense Authorization Act unconstitutional. She invalidated the law. She issued an injunction, which means that the ability of the military to seize American citizens, hold them in military facilities, strip them of due process indefinitely, was taken off the books. The Obama administration, the day that she issued the ruling, went to Judge Forrest and said, we would like you to put the law back into effect until the appeal is heard in the Second Circuit, which is the next level of the court before the Supreme Court. Judge Forrest, to her credit, refused. The Obama administration lawyers then went to the Second Circuit. This was on a Friday, 9 a.m. the next Monday morning. They went to the Second Circuit, and they again asked the Second Circuit to give them an emergency stay, meaning the law would be put back into effect. The Second Circuit gave them that stay. Now, this was quite disturbing to myself as a plaintiff, as well as the lawyers and the other plaintiffs, because it seems to indicate that they're already using the law. We knew they would appeal, but the fact that they appeal that aggressively, and they want to be able to call the military into the streets and seize American citizens and hold them without due process. You know, Judge Forrest, in her 112-page opinion, when she issued her ruling, brought up the issue of the 110,000 Japanese Americans who were detained during World War II and stripped of due process, as this provision within the NDAA essentially opens the door for that possibility.
Sadly, the appeals court ruled against Chris Hedges, and the Supreme Court refused to hear the case. Thanks to James Lee, Maria Cantwell, Patty Murray, and those who support those horrible politicians, and thanks to those who remain silent about SB 5176, let it not happen again, has been turned into legal to happen again. But we will fight this with your help. As always, we remain committed to the free exchange of ideas. Please join us on Bainbridge Island Uncensored.
Let me say this. Martin Luther King Jr. today could be taken to jail without due process or judicial process under the National Defense Authorization Act.
And put them in federal prison camps, actually prisons, and families knew not where they were sent, and there was no due process. And this is the issue. The issue is that anybody who is on the soil of this great country should be allowed due process guaranteed by the Constitution. And we are now moving back to the Dark Ages, where there are those that feel that we have the right today to eliminate that due process, to forego that due process, forego the Constitution in order to satisfy the whims of those in the military.
Regardless of where you live on this planet, no matter what your nationality, the fact that the indefinite detention provisions of the NDAA are still on the books should disturb you on a fundamental level. If not, give it 3 minutes. The National Defense Authorization Act, which was passed in 2012 and extended in 2013 and 2014, authorizes the U.S. military to arrest anyone, anywhere on the planet, to deny them access to a lawyer, and to detain them indefinitely without a trial. Furthermore, the U.S. government claims the right to do all of this in secret. No one would know where you went. You would just disappear. The right to a fair trial is gone. Without the right to a fair trial, you don't have any rights at all. Of course, some would argue that the NDAA only targets enemies of the United States, as if this would somehow make it okay. That defense doesn't hold water. It doesn't matter who the law claims to target, and it doesn't matter under what conditions politicians claim it can be used. If you don't have a right to a lawyer, and if you don't get your day in court, and if the government isn't even obligated to disclose the fact that they dragged you from your house in the middle of the night, then who is going to make sure that this isn't abused? The soldiers? The politicians? Come on. The power to make someone disappear without a trial is the power to make up any excuse that's convenient. Evidence is only needed when you have to prove your case in court. That's why we have courts. The protections codified in the Constitution were put there for a reason. But at this point, it looks very much like America is going to learn that lesson the hard way. Land of the free, right? You can put your hand over your heart, celebrate something that no longer exists, or you can be honest with yourself. That might be a bit painful. No one wants to believe that their kids are going to live under a military dictatorship. No one wants to see this coming. So most people put their head in the sand and do their best not to think about it. Those who don't always begin with one question. What can we do?